Welcome to our program today on health and labor law considerations for healthcare employers during the pandemic, hosted by Greenspoon Martyr. Before we begin, I just want to note that this session is being recorded. So if there's something we cover that you'd like to revisit, you'll have the opportunity to do so on our website in the next few days. My name is Shireen Martyr. I'm an associate in the firm's health law practice. I'm located in our Orlando office, and we're so pleased that you're able to join us today. I'm also pleased to introduce you to our panelists. They're both partners at the firm. Ron Lebo, he's in our New York City office, and he specializes in health law. We also have with us Adam Kemper, who is in our Boca office, and he specializes in labor and employment law. And there's a lot of crossover between these two practice areas, especially in the age of COVID-19. So together, Ron and Adam will be answering some of the most common and important questions that healthcare employers have been faced with in the time of COVID-19, and which is really new territory for a lot of employers. So you may feel free to ask questions. At the bottom of your screen, you'll see a feature for Q&A. And there you may input your questions at any time throughout the presentation. So we may answer them on the spot, but we'll definitely reserve some time at the end of this presentation so that we can answer more of your questions. So before I hand it over to Ron and Adam, I just wanted to give a brief overview of the state of telehealth. For many of us, working from home has been not a terribly difficult transition, and we're able to accomplish what we can at home. But that's not the reality for healthcare providers. There are rules and regulations and barriers to working from home. They cannot just set up shop at home and start seeing patients virtually. There's HIPAA. There's also regulations, requirements, really, impediments that have been created by the payers. So Medicare, for example, they impose a geographic restriction. The patient must receive the telehealth service in an originating site, which is pretty much a rural area, or an authorized medical facility. So it would require the patient to leave their home and go to an authorized medical facility to receive the telehealth service. That's a huge barrier. The other barrier imposed by Medicare is the services that they will reimburse as eligible telehealth services. They have added many throughout the years, but it's still a barrier. Medicare also places limitations on the frequency of services that may be done through telehealth. There's also a technology requirement that there be interactive audio and visual telecommunication system allowing for real-time communication. And then finally, and this is not an exhaustive list by any means, but reimbursement has been historically lower for telehealth than in-person services that have been rendered. Private insurers have their own rules and regulations, and they differ by plan. They're limited as well. And so the point being that there have been barriers to telehealth, and healthcare practitioners cannot just set up shop, begin seeing patients. It's never been that way, even for healthcare practitioners who can feasibly render medical services through video communication, where, for example, a medical evaluation is not required and there's no need for a physical in-person contact. Okay, so next slide. Okay. So during, when the pandemic began in mid-March, some of these barriers to telehealth were lifted in recognition of the fact that working from home will reduce the exposure to coronavirus, and that is critical. There's been flexibility in HIPAA. So there's been, for example, enforcement discretion and penalties that have been waived for HIPAA violations involving good faith telehealth service through commonly used remote communication technologies. Technologies that normally would not comply with HIPAA. Those are the things that they are exercising enforcement discretion over. So we're talking about non-public facing video technology, commonly used apps like Zoom, Skype, FaceTime. Those now are permitted, and you can render telehealth services through those commonly used apps. What is never acceptable still under HIPAA? Public facing video technology, obviously, Facebook Live or TikTok or Twitch. That would not work. Also, in the time of coronavirus, the DEA has allowed for waivers of the in-person evaluation requirements for the prescription of controlled substances. And that's provided that 3 conditions are met, that the issuance of the prescription is legitimate and in the usual course of business, that there's the audio-visual, real-time, two-way interactive communication system, and that it's still in accordance with state and federal law. And Medicare has also lifted barriers as well. They've lifted completely the geographic restriction. So whereas before, Medicare required that the beneficiary be located within a rural area or that they leave their home in order to receive the telehealth service in some authorized facility, now the patients can be anywhere. They can be anywhere in their home, and there's no restriction. Medicare has also expanded the list of eligible services. Now there are 180 eligible services. Before this, I believe it was around 100. They've removed some of the frequency limitations as well for the telehealth services. And they're also, they have enforcement discretion. They're exercising enforcement discretion for the prior existing relationship requirement. So now healthcare provider can see a new patient through telehealth.
Whereas previously, Shireen, they had to have a relationship with the patient within the past 3 years.
Exactly. Another important measure is that it's okay to supervise, for a physician to supervise through video. That's acceptable now under Medicare's rules. They've also implemented payment parity. So whereas before, historically, there have been reduced reimbursement for telehealth services, now they've mandated that those services be paid at the same rates as in-person services. And then finally, several major health insurers made policy changes to accommodate telehealth. The coverage still varies from payer and plan, but there were several big announcements. UHC, Cigna, all the big insurance companies for the most part they put some policy measures in place to accommodate telehealth service.
Generally, Medicare is a little bit more lax than insurance companies though, so keep that in mind. We do advise you to check each carrier one at a time to see if there are any loopholes or obstacles or hurdles you have to jump. Keep in mind also, a lot of people are under the false impression that you can conduct telehealth through what's called store and forward technology, where people will store answers to a questionnaire, and then the doctor will review it separately and then respond to the questionnaire and issue orders in the mental health space or otherwise. Medicare and insurers typically require two-way real-time communication. So that is, they've extended that to telephone, whereas telephone wasn't originally allowed. But generally what we know as video communication like Zoom is the gold standard for what people expect. But it's not necessary on the state law basis, because you don't necessarily need to see the patient. So don't just look at Medicare, but look at state scope of practice requirements. And notably, a lot of the insurers are expanding their requirements as well, or limiting their requirements as well. But mental health has seen a boon in terms of telehealth, which is naturally, that's an obvious repercussion. The originating site is pretty much going to be almost anywhere. And you'll also be able to use telehealth through your mobile phone as well. Now, one of the things that gets lost in the mix is the licensing issue when you're out of state and you want to treat people in other states. We've had some very opportunistic business clients who thought, oh, well, now they're not going to check on COVID treatments. And that could extend from just issuing orders for COVID tests. It could extend to mental health, it could extend to respiratory care, to nursing home discharge. And they're hiring doctors who may not yet have a license in certain states. The reality is, from an enforcement perspective, the government doesn't have the wherewithal, the resources to stop everybody that's doing this. And people are just assuming they won't get challenged for this, but one patient complaint can come back to haunt you. But what they have done is they've allowed doctors to apply for emergency licensing in various states. So it's expedited licensing, but it's specific to COVID. And that would include related issues relating to COVID, including post-recovery morbidity and organ failure and respiratory issues. But it expires either within a 30-day period or within a 120-day period, depending on the state. Some states do still require that there's a pre-existing patient relationship in terms of the licensure laws. Licensure laws are criminal laws. So if you practice in a state you don't have a license, then you're engaged in the unlicensed practice of medicine in that state, which could not only threaten you from a malpractice coverage perspective, because insurers might not cover that, but also could threaten your licensure in your own state. So check each state individually to see whether they require a pre-existing patient relationship. And certainly they expect that you're not going to open a permanent physical office in that state. It is not a permission to do that at all.
Okay, slide, please. Okay, so all of these barriers which have been removed, allowing for telehealth to be more easily used, have led to an explosion of telehealth during the pandemic. So in the beginning, in March, we went from 13,000 to 1.7 million telehealth visits per week for Medicare beneficiaries. By mid-June, this was over 9 million telehealth visits for Medicare beneficiaries. Private insurers have reported telehealth claims increased over 4,000%. People are using their insurance more, and this has actually led to a decline in profitability, not surprisingly, for insurance companies. So they're actually now starting to roll back some of their telehealth coverage that they put in their policies, starting to roll that back now. A number of them will end it by the end of the year. Some of them have already begun. And so, unfortunately, we don't know what the future of telehealth will be, if it will be like this exactly. Medicare wants to continue to make some of their flexibility in the telehealth coverage permanent. So we'll see, but
not necessarily for everything.
Not for everything, no, definitely not for everything. Just some aspects of it, for sure. And so with that, I would like to cue our first poll question. So this is a poll question for you, the audience, to answer. All right, so the question is, do you feel adequately prepared to prevent or respond to a COVID-19 outbreak in your workplace? Give you a few moments to answer. We'll have one other poll question for you. later on. So, all right, I think that's sufficient. Okay, 64% of you said you do feel adequately prepared and 36% no. So with that, I'd like to go into our first question for our panelists. What are some challenges that healthcare employers have endured during this pandemic?
Yeah, so thank you, Shireen, and thank you, Ron, for covering the telehealth component. I think that, as you pointed out, was an explosion during this pandemic, and sort of another explosion, or I don't want to use that term explosion, but a uptick has been employee-related issues in the healthcare space. And that's for a lot of reasons. And this is all during this pandemic. First and foremost, there is, we're dealing with frontline workers. These are people that have varying degrees of risk in terms of contracting the virus themselves, but certainly more risk than those that are able to do everything exclusively remotely. So there's the fear of bringing the virus home. There's, at many points during this pandemic, a lack of PPE protection for employees. And then there's employees actually getting COVID through patients or through coworkers, and possibly not having sufficient paid leave to cover their time off. And I'll talk about the law that's applicable during this pandemic. But all of this has resulted in the most reported cases out of any industry to OSHA, to the Occupational Safety and Health Administration. The healthcare space has the #1 highest amounts of cases reported to OSHA for potential violations of safety and health in the working environment. And that's a really serious issue.
Mm-hmm. So my next question is, both employers and employees are affected by work reductions and furloughs. How should employers protect themselves from compensation disputes, and what issues do employers and employees try to negotiate?
Well, two things I've noticed of happening quite often. Either I represent an employer and employee who sends or receives a letter saying that here's our new contract, or here's an amendment to our contract, and we expect you to sign it within X days, or we're going to consider terminating your employment. Usually these letters are very one-sided and include provisions that can and should be negotiated. On the other side of the coin is we have employees that are sending resignation letters, often sometimes properly, sometimes improperly, based on claimed COVID issues. In some cases, they're bona fide, but they still constitute breach of their contract. And then that's usually followed up with a threat letter from an attorney asking for past unpaid wages. Now, naturally, employers can't necessarily afford to pay people if they're not reporting in the office, and healthcare professionals tend to be the most hypochondriacal of all the people I've ever met. And a lot of people are fearful of not only catching it from the patients, but from their own colleagues. And certainly if they have young children or elderly family members in their home, they're much more hesitant to want to work. The inverse of that is a lot of patients sometimes simply are not showing up to offices, so the income potential of the offices is lower. So employers send these letters out, and the contracts usually have several traits. They include a release, and the release says you're going to release us very broadly for all past issues. And that's not just unpaid wages resulting from reduction in hours, and we haven't paid you your bonus yet, but anything, including harassment, discrimination. They're very broad-based language because we expect as attorneys, people are just going to sign those documents and expect them. Now, when the employee calls me and says, can I sign this? I say, well, we need to narrow the scope of this release. It can't be an overall general release. It should be limited to payroll issues during time periods that you weren't working. But that's only if you're interested in keeping this job, because if you're not interested in keeping this job, then we should fight for the extra pay. Now, often the employers aren't looking for new jobs and they don't expect to find them necessarily. and they're happy with the arrangement where they are. So what we do instead is we ask the employer to limit the release to certain wages and true up any past bonus payments that haven't been paid yet. So often bonuses can be determined based on annual aggregate metrics, such as work RVUs or collections. And usually there's a threshold the employee has to reach before they get paid a bonus, whether it's a certain number of thousands of RVUs in the year, or whether it's based on a certain number of threshold collections in the aggregate for the full year. Now, the employer may nevertheless pay in advance on those bonuses throughout the course of the year, but they're not necessarily earned until the year's up. Now, we're halfway through the year and the employee hasn't been working for 3 months of those 6 months. So naturally, we already know that their chance to earn a bonus when the next 9 months passes, 6 months passes, is practically nil because they haven't been generating as much RVUs as they should have or earning the income and collections that they should have. So I'll ask on behalf of the employee to true up the bonus based on a prorated calculation and recognition that they were deprived of the ability to work towards that incentive, which is a critical component of their compensation package. Now, if you're also going to ask me as an employee for future permission, which is often in these contracts, future unilateral right by the employer to reduce my hours, to send me home, to furlough me, or to eliminate my bonus going forward, which is often the case, then I want mutual assurances. I want assurance that you're not going to cherry pick your favorite people. I want to know to stay in the office. I want to know that if Dr. Smith is going to be working, that I'm working. Or if you're sending people home, you're sending everybody home. So you want very benign language that says you're going to treat me consistent with other people. And beyond that, if you're going to require me to work at home, but I'm willing to come in, and a patient wants to see me or a referral source requests me, I want the unilateral right to go in if I choose to, and I'm willing to assume that risk. Now, often I'm also subject to a contract that requires me to give notice, broad notice, before I can leave. And because I've already been stopped from working and I've taken a pay cut across the board, or haven't earned income for a certain period of time, I'd like to know that if this happens again and that there's a furlough that lasts too long, that you're going to allow me to give shorter notice. If my contract requires me to give 6 months notice, I want to say in the event of another furlough, I can reduce that notice to 30 days. That way I can find another gig and get work. Now, beyond that, contracts have exclusivity clauses, which say that if you work for that employer, you work only for that employer. So I can't moonlight. I can't make extra money on the side. I'm going to ask you as the employer to relax that requirement as long as certain parameters are met. Potentially, I'm going to take a gig outside of a restricted area where your patients come from. I don't need to seek your permission if I'm going to another location. I don't need to seek your permission if I'm doing out-of-state telehealth or telehealth in an area you don't service. Relax those exclusivity restrictions. And then lastly, if an employer breaches by not paying just because they think there's an executive order that says you don't have to remain open because we're purely elective procedures, well, I as an employee can get out of my post-termination restrictive covenant in many states under the case law. In other words, I can say you breached, employer, I don't have to give you any notice, and I can go work across the street. And that's a defense unless the contract expressly disclaims that defense. So employers are very often amenable to relaxing the restrictive covenant if you leave as a result of a subsequent furlough. Not generally and for no reason, but if another pandemic spike hits, they'll relax that requirement. So, it has to be understood that just because there's an executive order or guidelines that say elective procedures should not be offered, people still, if you have a written contract, breach claims still exist. And unless you've been ordered by the government to close and no one's working, then you're certainly going to be subject to some sort of argument later when somebody wants to leave and wants more money or to reduce their covenant and go to work for a competitor. Now, lastly, employers need to integrate what Shireen was talking about into what's going to happen going forward and anticipate the changing reimbursement parameters and rates that the employee and the employer can expect to earn as a result of telemedicine. So we're more often drafting telemedicine clauses that discuss the telemedicine requirements and altering the compensation structure based on those requirements as well. So there's a lot to talk about, and it shouldn't just be disregarded as somebody is sending the letter or receiving the letter. And if somebody receives a threat letter and they do owe past money, well, think about alleviating the restrictive covenant as a common negotiating tactic.
Awesome. Thank you, Ron. That was so detailed. We can now just handle this matter ourselves. Awesome. So, okay, next question we have. All right, what are some tips you can provide to healthcare employers to avoid a workplace lawsuit or governmental audit? And what are practical strategies for employers to limit claims involving contraction of COVID on the premises and opportunistic patient complaints about exposure?
If I could just start out by just saying broadly what we're talking about here is there are 4 types of claims that we usually get. There's your standard negligence and malpractice claims. And then there's negligence per se. And then lastly, there's fraud. There's also been a unique new claim that's being brought, which is public nuisance. Negligence and malpractice are just what would a reasonable person do under the circumstances. Malpractice is what would a reasonable doctor with the knowledge of healthcare do under the circumstance. So it's a higher standard to meet. Negligence per se means that you haven't complied with the law. And so you're liable because you ignored an executive order or OSHA or CDC or your accrediting organization's guidelines. And then fraud is based on advertisements. Don't worry, we implement the best PPE practices, bring your people in, you're safe. Fraud claims will be brought based on your advertising practices. And then lastly, public nuisance, which usually was reserved for interfering with a public right, such as I have the right not to be in a smelly home, or I have the right not to hear noise, is being used as a tool to launch lawsuits. So that's what we're dealing with, Adam.
Yeah, I mean, those are some great perspectives in terms of possible patient claims. From the employer's perspective, I always think about, what steps have you taken to eliminate the risks, to eliminate safety-related issues, to show that your working environment is a safe one and a hazard-free one? What documentation do you have in place? What policies and procedures do you have in place? Are they up to date if you have policies and procedures? There's a ton of information out there. There's some great attorneys that can help you with this information. And the key is to have that all together in place. And that's sort of step 1. And then step 2 is to properly train your employees on how to avoid hazardous situations, when to report, let's say, a workplace injury or a COVID case, and then have management or HR personnel be trained on what to do in the situation of a workplace injury, of a COVID scenario, and have training on all the steps to take following that report. Because really what we're looking at is a company is going to be scrutinized by not necessarily a COVID case coming up in the workplace, because it's going to happen everywhere, but how they respond to it and how they mitigate that possibility. So again, it boils down to what have you done to avoid the issue? And then once the issue has come up, because it will, every workplace is going to have COVID. What have you done to prevent it from spreading and to alleviate the risk for other people? And it boils down to compliance and working with attorneys such as ourselves to ensure that you're fully in compliance.
Now, here's what you need to understand. The biggest hurdle for somebody to prevail on a claim of malpractice or negligence is causation. And obviously, it's, with the pandemic as widespread as it is, it's very difficult for somebody to prove they contracted the virus while on your premises. But that doesn't mean you're not going to be in a storm of legal fees and defenses. And the reality is, in this case, you're in large part at risk because your license is at risk. Your right to continue to provide healthcare is at risk, and you're subject to regulatory oversight by Medicare, payers, CDC, OSHA, DOH, local authorities. So you still have bigger problems than just avoiding the proof of causation. So you want to look at it this way: enforcement, enactment, enforcement, response, and documentation. Documentation being the cornerstone of all of this, because if you don't write it down, you're going to be unable to present a defense. So enactment, you implement policies and procedures governing COVID. You appoint somebody in your office to actually train people on those policies and procedures. You document the training. You have somebody keep track of different and changing guidelines as they come up, and then retrain and redocument the training. Enforcement, you have systems and open door policies and mechanisms for anonymous reporting or open door discussions and reporting of people not abiding by hygiene policies. You have certification that people are trained in how to fit PPE, and they maybe have to enter a log that they actually put their PPE on, because I had one issue where a patient claimed that the doctor didn't have PPE, but we were able to show that we actually put it on them and we signed them up as saying on. So that eliminated the claim. If you enforce, you want to issue warnings and you want to retrain. And in some cases, you want to discipline. Now, response. If there's an outbreak, how did you clean? How did you move this? How did you quarantine that space? How did you trace other people in the office who had contact with a patient who tested positive or employee who tested positive? What is your response? Document the response. There is no defense without documentation. Now, a lot of states have passed immunity laws and they run the gamut, and some of them differ depending on whether it's a nursing home or medical office or whatnot. But none of these states give blanket immunity. Immunity laws do not allow immunity if you evidence willful or intentional misconduct. And that's doing things obviously purposely bad. But then there's the other things. There's reckless disregard or gross negligence. And both of those are sort of the same thing in essence, where you're aware of the risk, and we're certainly all aware of the risk. We're inundated with this fear over all our airwaves at all times, and you completely ignore it. If you don't enact, enforce, train, and document, it by itself, the omission demonstrates reckless disregard, and your immunity goes out the window. And your malpractice carrier may disclaim liability protection under those circumstances. You have to have procedures in place, but don't get me wrong, it's not same size fits all for everybody. But if you decide that there's an OSHA guideline or a local guidance or an executive order that you can't comply with, or your accrediting organization is too strict, or because they drafted it for a hospital and you're just a two-person office, in that case, make a documented note of the guideline you didn't implement and why you didn't implement. Too expensive, too few employees, everybody's working from home, and the alternative approach to mitigating that risk. Now, there are other things that you should implement. That's signage on the walls saying everybody should wear a face mask, handing out something when people come in where they acknowledge that they haven't had exposure to somebody with COVID or had symptoms in the past 10 days or tested positive. You limit the visitors that can come to either immediate family, either to the patient or their immediate family member, or to people who are empowered to make healthcare decisions on their behalf, and forbid other people who are not associated with that process, that decision-making process, from coming in at all. Limit, to that note, limit the contractors that can come in. You don't necessarily need to give access to sales reps anymore, right? And that may lose some people some dinners and some gifts, but limit who can come on site. And then look at all your contractor agreements. Make sure that you update them or review the ones that are presented to you for cleaning, for instance, or otherwise, to actually have them assume the affirmative risk of exposure, to assume sole responsibility for their own outside personnel's conduct and cleanliness and hygiene within your four corners, and to indemnify you if somebody sues because of something a contractor did.
So in an effort to reduce the exposure to the virus, can employers screen employees for COVID-19, or can they require them to take COVID-19 tests?
Yeah, and the answer is yes. And my recommendation is that they should, and that the screening should be daily. So yeah, I mean, there's many types of screening that can occur. First and foremost, temperature. Okay.
Mm-hmm.
With temperature screens, that you have to have someone that has, some knowledge as to what they're doing, has an accurate temperature gauge to measure someone's temperature, and that they're sanitizing it and cleaning it and taking the necessary precautions to ensure that they're not creating additional risks through something that's intended to mitigate risk. And then secondly, and this issue comes up a lot, from a wage and hour perspective, I get questions all the time about, should we be paying employees while they're waiting to be tested, while they're waiting to be screened? And the answer is yes, you should, especially if it's more than 30 seconds, 60 seconds, 20 seconds. If people are waiting in line to get their temperature checked, or if they have to complete some self-reporting requirement, that should be compensable on the clock, okay? There's other types of screening as well, which is the self-reporting of any symptoms. Are they exhibiting any symptoms consistent with COVID-19? Have they done any travel? Things like that. That should be a regular part of everyone's requirements for their employees.
Have they traveled to a state that's suffered a spike? Have they traveled internationally?
Right.
Have they had contact with someone who has?
Exactly.
Usually when somebody comes in to the office, it's best practice to have a screening questionnaire there on site. Real best practice is to have them do it remotely before they come in. But if they are going to come on site and you're going to screen them with these questions, the best practice is to have a segregated location within the office that's separate and apart from the waiting room, so people aren't getting temperature checks in front of everybody and they're not filling out these questionnaires in front of anybody. And obviously, if somebody has a temperature, send them home.
Right. The only other thing I was going to add is that in terms of screening, if a question comes up a lot, can we require our employees go get a COVID test before they can, let's say, come back to work if they were traveling, or if there's a suspected case that they may have come in close contact with somebody else that has COVID, or as a prerequisite to beginning work with the employer? And the answer to all three is yes. The only caveat, and this is provided by the U.S. Equal Employment Opportunity Commission, is that the test that you require your employees take, they must be accurate and reliable, okay? So this can be at CVS, but maybe not 7-Eleven, okay? This can be at a reputable healthcare provider that provides tests. They're accurate, and yes, you can rely on that to make an employment decision, and you should if the circumstances warrant it. The unfortunate reality is, to this day, no tests are 100% accurate. There's still false positives. There's still false negatives. Rapid test centers are spreading throughout the nation, so there are opportunities to get rapid results. But there's still many areas throughout the country where there's a 3-4 day waiting period to get the results back, and the employee should not be on the work site during that waiting period. So you can do testing. It should be accurate and reliable. And one thing to keep in mind, and we talked about this earlier, I know Shireen and Ron, you'll want to jump in on this, but you got to make sure you comply with HIPAA and privacy rights of employees when you retrieve their medical information.
Let me touch on the issue of testing while we're on it. You have antigen testing, antibody testing, and PCR, which is RNA testing. PCR is the most gold standard of testing. It shows the active diagnosis. The antigen and antibody may show the presence of antibodies or that you had it in the past. Now, the CDC has even said that a negative test isn't definitive proof. The best proof is whether or not you've been symptomatic or not and how long you haven't been symptomatic. So if you've been asymptomatic, they're looking for at least 10 days from your first positive result for the test to make any difference, and there's been no further symptoms. If you were actually ill and sick, it's a 3-part test. It's been at least 10 days since your first positive result. You haven't had a fever in the last 24 hours, and that's taking into account whether or not you've taken an Advil or acetaminophen, and you shouldn't, if you were, then that doesn't count. And lastly, that you haven't exhibited symptoms for a certain period of time. So it's really about symptomatic versus testing, and that's the time frames that we want to be beholden to. The incubation period is 2 to 14 days, But generally 10 days after your first test, if you haven't had any symptoms, you're okay. In terms of immunity and liability, a lot of people think, I saw on the internet, I'm gonna have visitors and patients and employees sign a waiver that you can't sue me if you get COVID. Now, as a matter of course, that's against public policy, and as lawyers we say it's unenforceable as against public policy. You can't do bad and expect to be not held liable. It's just not true. But it could be evidence, if you've done it, that you've at least put people on notice. I think that's a weak argument, but I've had lawyers say that to me in the past. At the end of the day, follow OSHA, follow Joint Commission or accrediting organization guidelines, follow CDC, follow state guidelines, and that'll prove reasonableness, that you acted reasonably under the circumstances, and that'll help you withstand most claims. But documentation is still the biggest protection for that.
I just want to add one point as to the waiver argument, because I also get that question. Adam, can we require that our employees sign a waiver that they can't sue us if they contract COVID while in the workplace? And the answer is no, you should not be doing that, okay? Because first and foremost, if someone gets COVID in the workplace, they may be entitled to file a workers' comp claim. They may be entitled to go to OSHA. And you cannot get in the way of their filing of a workers' comp claim. There's actually statutory laws strictly prohibiting that, and likewise with OSHA. So absolutely do not recommend liability waivers for employees for those reasons. And then secondly, for the message that you're sending to your employees, which is, you may very well get it, but we don't care because you can't sue us. That's a message that a lot of employees may infer from having to sign that type of thing, and you might get people walking out the door of that company. So I'm totally against it, even though I know some companies are requiring it to this day.
Mm-hmm. So keeping on this topic of testing, can an employer take and maintain records of an employee's temperature without violating privacy and employment laws? You mentioned that, yes, we can, but can you elaborate on that? Because doesn't this conflict with some privacy and employment laws currently in place?
Yeah, I mean, they can absolutely take these medical tests. The EEOC has commented on this, and we're in the midst of a pandemic. You can require that employees take these types of tests as a condition to employment, but that does not excuse your liability with respect to HIPAA and privacy. So you still have to maintain this information as private and confidential. And I always say, when in doubt, if you feel like you might have partial verbal consent from an employee to share they've tested positive, when in doubt, get their written consent to share whatever agreed upon language the employee will allow you to share with other people, so that there's never an issue of possible HIPAA or privacy violations.
If you're not subject to HIPAA, still get the consent. If you're subject to HIPAA, you would need the consent to disclose it to third parties, in particular, sharing it with other people other than authorities, other than the leadership that are overseeing the compliance program for COVID, and other than family members. So HIPAA authorizations are still in play. They're not out the door. Enforcement's gone down, but they're still in play. And what I'm concerned is some retroactive look back that's facilitated by a patient complaint to OCR. And if they see a big organization that just failed to get authorizations, that's a 6 to 7 figure fine that people are looking at a year from now. So documentation, again, is the cornerstone of all of this compliance. Also, the records on the testing should be maintained separate and apart from the individual personnel file. You can have a collective personnel file that has everybody's temperature, and that's tracked over time. And that could be used in a defense if you're sued, that you've been tracking it and keeping track of exposure risk in your office.
So at this time, I'd like to cue the second poll question for our audience. Have any of you had employees refuse to work due to fears relating to COVID-19?
Yeah, I refuse.
Me too.
Like a lot of people, have generally Healthcare workers want to work because they want to make money, but like anybody, if telemedicine is an option, they take it. But in this space, it's often not an option. If they're under contract, then that's breach. That is absolute breach of their contract.
Let me comment on that. Let me comment on that, because with respect to employee fear, we can't just write it off as they're refusing to work. Because if the fear is related to some safety issue, some workplace hazard, they could have rights under OSHA, and they could be considered a whistleblower if they're fearful because you don't have everything together with respect to safety and workplace hazards. If you're doing everything you possibly can and the workplace is completely safe and you've never had a COVID case, then that fear is not rational. Okay.
So let's say an employee has an underlying health condition and they're more vulnerable. Would that suffice? Is that something that they would be able to refuse and it would be fine?
Yeah, I mean, that 100% pops up, and it's really a balancing act with an employer. Okay. So I always say, let's not write this off. Let's evaluate this to see, is there some middle ground here with this employee? Because we send this employee away, not only is that going to look bad, but that could be a violation of, let's say, the ADA, disability discrimination. There could possibly be rights under Family Medical Leave Act, depending on the size of the employer. There's also the Families First Coronavirus Response Act, which we'll touch on in a few minutes. So the key for the employer is to have, if they have an HR personnel, great. If not, they need to have someone sort of issue spot this to know that this is something they need to look deeper into, and they need to talk to an attorney to handle this properly. Because if it's not handled properly, this could be major exposure for the company. So
yeah, I mean, don't take my aggressive stance as gospel. You certainly want to ensure that you're not going to be subject to a discrimination complaint. And in these days when people want payouts, it's much more likely and guaranteed you're going to get it. So be proactive and reach out to people like Adam, who are employment law experts, to make sure that you've dotted all your I's and crossed your T's.
So to follow up with that, can employers send home employees who exhibit COVID-19 symptoms?
Yes, and they should. Right now, there's really not going to be any hard feelings about sending employees home. The only hard feelings are if there's no room for that employee to be paid while they're out on leave, either under the law or under the employer policy. So then that runs into the issue of, should employer be instituting some policy for paid leave, even when they're not legally required to, so that employees are, let's say, not hiding their symptoms. They're being forthcoming when they're self-reporting and abiding by your requirements. And, they're not fearful of missing work due to loss of pay, because frankly, pre-COVID, people work sick all the time because they don't want to go out on leave. They don't want to go out on, they don't want to lose their jobs. So if the employee has the comfort of knowing that that they'll be receiving pay and that they'll have their job when they come back, then they're more likely to report and be sent home when they're
Adam, could I, as an employer who doubts an employee's veracity, require them to have a medical certification substantiating their reason for this specific accommodation they expect if they refuse to work?
Yeah, so that's certainly part of the analysis. A practical issue now is that doctors are inundated right now. So if, let's say, you ask for a doctor's note by X date and it's not produced on X date, the key word is flexibility. So being as flexible as you can. But yes, you don't have to take someone's word for it, but you also don't want to play doctor, or at least their doctor in the case of the medical practice, because you haven't evaluated this person's medical condition. So you're not in a position to judge whether it's legitimate or not. So there can be some back and forth, and it's pretty typical. but just be flexible. Right now, flexibility is the key, and every federal agency is talking about that. Be as flexible as you can with your employees. It will go a long way.
Mhm. So Adam, you briefly referenced before the Families First Coronavirus Response Act. What can you tell us about it and its applicability to healthcare providers?
So I'll touch on this briefly because I know we're running out of time, and I want to make
Mhm.
sure our audience has time to go through their questions to us. But basically, this is one of the government initiatives that was instituted effective April 1, 2020, which mandated that every employer with 500 or fewer employees be required to provide paid leave for their employees when they either contract COVID or have symptoms related to COVID, or maybe have childcare responsibilities related to COVID when school closures and daycare centers were closed because of the pandemic. So with respect to healthcare, there was a carve out in the initial regulation, which gave a broad stroke to healthcare providers that essentially said all of their employees would not be entitled to leave under this act. And the rationale is that government says you need to work, you need to be there. We can't afford to have you take this time off, which is kind of messed up, said lightly. And on top of that, there was the practical issue of, well, what do you mean by that? Are we talking everybody that works for a healthcare employer can't get paid time off, even billers, IT personnel, record managers, food service workers, HR personnel? These people can't get it? Well, that raised issue with the New York District Court in August. The New York District Court came out with a ruling, which the U.S. Department of Labor reviewed and agreed with in part, and it has recently clarified the issue with respect to healthcare providers. So as of September 16th of this year, the carve out, which previously said basically all employees are not entitled to leave under this act, has now said only the people that are performing diagnostic services, preventative services, treatment services, or other services that are integrated with and necessary to the provision of patient care. Okay, those are the people that are excluded from paid leave under this act. But people who are not doing those types of services, for example, the billers, for example, the IT personnel, the HR personnel, the people that are not really acting in the provision of care, those people could be eligible for leave under the Family First Coronavirus Response Act. Why is that important? Healthcare providers thought they were in the clear, didn't have to provide leave under this act, and now they may have to with respect to a group of employees. All the more reason to consult with an attorney to see what your requirements are when someone has COVID-19, and to see if this is a law you need to abide by.
Okay, so we do have a few minutes left for us to answer some questions from the audience. Let's see. Okay. What if your state laws regarding testing are in conflict with federal laws or CDC policy? Do you have thoughts on that? Can state laws be more stringent than federal laws and CDC guidelines?
Yeah, I'll jump on that first. I mean, look, you want to be ultra compliant and comply with CDC guidelines because they are guidelines, okay?
Right.
Let's keep that in mind. And if you have a state law or even a county ordinance, which is stringent, these are legal requirements that if you fail to abide by them, you're in violation of the law. So it is important that you not only evaluate the federal laws, the federal guidelines, but also look to the state and local ordinances and laws that may pertain to your business, that may pertain to testing, and that you abide by all of them. So that's why we're here. We're here to help you guys stay in compliance with this stuff.
Mm-hmm. Right. You have to remain in compliance with both federal and state laws, and there cannot be any conflicts about that. So let's see other questions. Okay. What about indirect exposure risks and reporting? If a spouse's coworker had a positive case, a kid's classmate was positive, etc., does the employee need to report that and quarantine?
So I have that issue pop up all the time too. And I say, when in doubt, if it's a close call, send the employee out to go get tested, and self-monitor and self-report if they have the symptoms, because as Ron pointed out, I thought it was a great point. The key is the symptoms now and the time that has elapsed from having those symptoms. So that doesn't mean you go out for all 2 weeks or even longer. It may just be go get a rapid test, monitor your symptoms, especially if this is someone that needs to be on site. If this is someone that can work remotely, have them work remotely. No downside to that. But if this is someone that you need on site, then have them sent out for a test, have them self-monitor, self-report. And once you have confidence that you have the negative test, you have no symptoms, and possibly you get a doctor's note, those 3 items, that should be sufficient to bring that employee back.
You want to avoid crossing privacy barriers, boundaries. You don't want to necessarily say, tell us if your spouse or daughter or grandmother has it. Or you want to say, tell us if somebody you've been in close contact with has it. And close contact definition has been shifting to being exposed to somebody for an aggregate of 15 minutes over a 24-hour period. So close contact is the key there. You're not prohibited from saying, tell us if your daughter's school closed or your husband's workforce closed because of an outbreak, but close contact is the moniker you want to use.
Mm-hmm. Okay, and last question here. During the pandemic, what kinds of things that might normally be considered supervision or appropriate for supervision or provision of workplace materials like masks or gloves, what kinds of things can be done with those who are registered with one's nurse registry, for example, for referral to clients? Can some of that be done by others? One example listed here in this question, can training be given or guidelines with a risk of joint employership? Can the self-employed CGs be required to get tested periodically in order to continue to be referred?
So happy to jump on that too. Look, there's going to be a balance between preserving the independent contractor status between a nurse registry and the caregivers versus possibly imposing or taking a part of inflicting the virus onto your customers. And look, should training be done? No, these people should come and self-train. Should they have their own materials? Yes, they should have their own materials. I do think the onus is on the nurse registry to ensure that these people, when they're sent out to the patients, that they are in compliance as best they can, and that there is some diligence that's done before sending these people out to your customers, because they are your customers, and you could be on the hook for exposure if you don't take the necessary precautions. So it is a balancing act, but I think the balance needs to weigh in favor of taking those necessary precautions, especially during this pandemic.
And being mindful of the transfer of the onus by contract, which I had a client that sent doctors to nursing homes, and we ensured that the nursing homes took full responsibility for the PPE and for the training, even though we were going to do it ourselves to avoid liability. An extra layer, we still transferred the onus on the client. In that case, it was the nursing facility.
Okay, so I think that concludes our time. Thank you everyone for joining us. And okay.